I think it can start, Blake.
Okay. So I was gonna start with going over the different type of trusts that are there out there. What are some advantages? What are some disadvantages of those trusts? And then just roll into some estate planning pieces of it. Wills, living wills, power of attorney. How long do I have, or how long do you want me to speak for?
As long as you need. We typically meet for about an hour, 1 hour, and
Okay.
if needed, we go over. But
Okay, I'm not going to talk for an hour. I don't hear myself talking.
Well, what's good is to talk for like 45 minutes and then allow questions, or 50
Sure.
minutes. That's the ideal.
Okay. So, one of the first things that everybody, asks, especially in New Jersey, is like, do I need, a living trust? And what I say to people is, why do you want a living trust? And they'll say, well, I heard that I would need to use it to avoid probate. And then I tell them, probate in New Jersey is not a big deal. Who did you hear it from? Oh, I have a friend in Florida that has it, and they say you got to have one. So for Florida, every jurisdiction's a little bit different. That's why you have to kind of know, where that person's from or where they're domiciled, because they may have a house in Stonebridge, but they may be a resident or domiciled down in Florida. So that means they spend 6 months in a day in Florida and less than 6 months in a day in New Jersey or somewhere else. So that's one of the key questions, to figure it out is, they have a living trust because in Florida, probate's time consuming and it's expensive. While in New Jersey, it's actually very simple. Probate's, easy. So what happens is that when somebody passes away, you can't probate the will for 10 days. And then on the 11th day, you can go to the Middlesex County Surrogate's office. You probate the will, which means you bring in the original will, the original death certificate, and then you pay $150. And maybe a few days later, you're good to go. You have letters of testamentary, and you're ready to administer the estate. So in New Jersey, it's a very simple process, and it's for every county there is. So all the way from Cumberland County, all the way up to Warren, Sussex, Morris, it's the same process. So that's the great thing about New Jersey. It's very a uniform state. So everything that you do in one county, you do it in another, and it makes it very simple. So when people say you got to have one, you really don't need a living trust in New Jersey. However, if you owned out-of-state property, you would have a living trust. So, but you're going to say, Blake, you just said I don't need one. And I'm going to say that's correct. If you only own property in the state of New Jersey, a living trust is not needed for your assets. Because again, probate in New Jersey, simple, easy, no big deal. But if you own property out of state, then you want to have a living trust. And the reason why you want to have a living trust for property out of state is to avoid probate in that state. So if you lived, primary residence was New Jersey, and you had a, winter house in Florida, well, you want the winter house to be in a living trust, just to avoid probate, in Florida. Or let's say you had another house in, New York. You put it into a living trust in New York, so you wouldn't have to probate or deal with any probate issues in a foreign jurisdiction or outside of, your home state of New Jersey. So that's where, we see a lot of advantages for when you would need a living trust. So property, you own out of state, think of that, got to have a living trust. If you just have property in New Jersey, you really don't need a living trust, because a living trust doesn't do any tax benefits. All it is a way to avoid probate, or, and for privacy purposes. So if you're a very private person, you don't want people to know where your assets are going to go or who they're going to go to, then you would want to have a living trust, because once you probate a will, it's a public document. So, if Len were to pass away and I wanted to know what Len's, will says, I can get a copy of his will because it's probated, it's public. Anybody can get access to it. While if it's a living trust, the living trust is going to say, I leave everything to the, Blake Laurence living trust, but nobody knows the contents of the living trust because it's not a public document. So those are some reasons why you would want to think about maybe setting up a living trust for property out of state, privacy reasons. But those are really the main reasons why people would want to live in trust. And the beauty is it's revocable. So that means you can change it whenever you want. There's if you want to add property in, take it out. If you want to change beneficiaries, all it is amending the living trust. So there is people do like that flexibility as well. So there's a lot of advantages, to a living trust, but there's some disadvantages in the fact that they're a lot more expensive as well in terms of costs. And the costs for living trusts go wild. They could be, as low as $1,000, and I've seen them for $3,000, $4,000, $5,000. But conceptually, they're all do the same thing. It's just a mechanism to avoid probate. And again, probate in New Jersey, not a big deal. If you have out-of-state property, then you would want to have a living trust for that property out of state. And all that means is you're doing a deed change. So we're changing the deed from, your Florida house, from yourself and maybe your spouse individually into the name of a living trust. You still own it. It's your social security number. You can sell it whenever you want. Again, there's no tax benefits to a living trust. It's just a way to avoid probate. So that's usually like one of the biggest, questions that we get is, what is a living trust? Do I need it? Susie Ormond says I need one. Everybody should have one. The answer is no, you don't need one unless you own, in my opinion, property out of state, or you're looking for privacy because you don't want your will to be public. Makes you wonder why, when people pass away, usually actors like James Gandolfini, Michael Jackson, or those, prominent actors where their will is published to everybody, why they didn't have a living trust. Because everybody knows the contents of their will because it's public, but if they had a living trust, it would have been easy to make it nice and protected. Nobody would have known their contents but their beneficiary. So that's one type of trust. And then that's what they call irrevocable trust, because you can change it whenever you want. And then you have things like that are irrevocable, meaning, once you make it, you really can't change it. You're not supposed to change it. That's the part of it. And that one has your tax benefits. So an irrevocable trust means you lose access and control over the assets that you put into it. So that's what you might see commonly, like what's called an ILET, an irrevocable life insurance trust. So some people may have very large life insurance policies, but they don't want to have that life insurance policy added to their estate, because although a life insurance policy is income tax free, it's not estate tax free. So right now in New Jersey, there is no estate tax. It doesn't mean it's not going to come back at some point in the future. With Murphy winning the election and looking for money from all the money that they gave out during COVID, I wouldn't be surprised if the estate tax comes back for New Jersey. At what amount? I'm not sure. And also with the Biden administration, they're potentially looking at lowering the threshold for the federal estate tax. Currently, the federal estate tax is $11.7 million. Could that change to $5 million? Sure, because most people aren't going to care because it doesn't affect them. But in New Jersey, you have a house, you have a life insurance policy and some other assets, you could be at the $5 million mark sooner than you would think. Most of the country isn't going to care about this, but for the your higher net worth individuals or those with large life insurance policies, it can become a real problem. So people will do what's called an irrevocable life insurance trust, where you'd put the policy into the trust. You're no longer the owner, the trustee is the owner. And it's therefore you have a 3-year look back if you transfer it, and then it's outside of your estate for tax purposes. And you can set it up the same way. You can have the income going to your spouse, and then when your spouse passes away, whatever's left going to your kids or whomever it may be. So that's a very easy and simple tool to use if your estate starts to creep up, where you may potentially have a federal estate tax, or if they bring back the New Jersey estate tax, a New Jersey estate tax issue. A very simple concept, very common. Before they got rid of the New Jersey estate tax, but we may be seeing that again. And then there's trust for basically anything that you can think of. There's trust that people will do, which is called, inter vivos trust, which means trust that you create now during your lifetime. So that could be for, you have, kids that you want to leave money to, but they're not ready to do that. But you want to gift it out of your estate, because right now your gifting ability is $11.7 million. That could change if they lower the federal estate tax. Your $11.7 million, will lower to that $5 million range as well. So therefore, there's a lot of people that are going to start gifting assets in anticipation of the Biden administration potentially lowering that estate tax or the gift tax to the $5 million mark. Also, you might do Medicaid trusts. So Medicaid trusts, are becoming more and more popular as the cost of healthcare gets more and more expensive. People that may not want long-term care insurance, or it's too late for long-term care insurance, may start to move assets into an irrevocable trust. But again, they're taking it outside of their estate. With Medicaid, it's a 5-year look back. So they're going to move it now. They're going to lose ownership and control. But if they get past the 5-year look back period, now that asset that they moved over is not part of the resources available for Medicaid. So it's a way for people to start planning, if you plan early enough, to move assets in anticipation that you may, at some point in the future, need to go into a nursing home, and you don't want to have to pay from your personal assets. You'd rather have Medicaid, pay for it. So that's a different type, that's one type of trust that you can do. There's more complicated trust. There's also trust for people that have, as they say, addiction issues, like it could be drugs, gambling, alcohol, where you still want that individual to benefit, but you don't want them to have the money to, do one of their vices, whether it's drugs, alcohol, or gambling. There's trust for, for those type of people or family members that might have those issues. And there's also, special needs trust, which is unfortunately is becoming more and more popular, where you have, adult children with disabilities that are on government services, and you want to provide for them, but you can't give the money to them outright. So that's when a special needs trust would come in, and that special needs trust will cover the extras in life for them. So for example, the special needs trust could, get them a house, but the house is owned by the special needs trust. It could get them a car to get them around, but it's owned by the special needs trust. It could pay for cable TV, or go pay for vacation. So, and then the reason you do a special needs trust is because you want to make sure that the person that's getting government services doesn't lose those government services. So therefore, that's where most people will do a special needs trust for their children, adult children, their grandchildren, et cetera, just to make sure that their money is going to, the benefit of their child, grandchild, whomever, and the government's not just taking their money. So I'd say those are probably some of the most popular trusts that you will see out there. But again, for most things, if you have an idea of what you're looking to accomplish, myself or any, attorney that specializes in this area can assist you with meeting your goals. But, if anything you take away from the trust piece of it is an irrevocable trust is really for tax planning. Or Medicaid planning for the most part, while irrevocable trust is basically for avoiding probate and for property out of state. So that's kind of like the key takeaway when it comes to the two revocable trusts versus irrevocable trusts, and then the pros and cons to each one. Because the pro to an irrevocable trust, it's not in your state for tax purposes. That sounds great. The con is you lose access and control over that money. So you have to be willing to give up that money to the irrevocable trust and not want to bring it back. Could we get it back? Could we make changes? Yeah, we could. It's irrevocable, but it's not really irrevocable. There is ways around it. It's just more of a process. But don't give anything to an irrevocable trust that you would want to have back, because then you're defeating the purpose of taking it out for Medicaid purposes or estate tax purposes. If you need the money and you're going to spend it, then obviously you should keep it. So those are some different trusts that may be out there. Does anybody have any specific questions or has a question on the trust piece of it?
Yeah, Blake, it's Morley.
Hey, Morley.
Can you talk about the tax situation of a revocable versus irrevocable? No, is it stepped up cost basis in one, both, or what?
Sure. Yep, that's a good question, Morley. So what Morley's talking about is a step up in basis. So what a step up in basis means is that if you owned a stock, let's say you bought Apple stock at $1, and now it's worth $100. If you have a step up, when you die, that means your heirs inherit it at $100. That's great. You then sell it for $100, you pay zero income tax. Versus I have the stock with Apple for $1, it's now worth $100. If I sell it, I got to pay capital gains tax on $99. So that's an example of the basis step up, which you get on death, but you only get that if you have a string to bring it back. So for example, when you have a revocable living trust, you still own it, right? You still own the asset. You can change it, you can sell it, you can buy more. So if you die owning a asset in a revocable living trust, you get a step up in basis. So in the earlier example, that Apple stock that you had that's worth $1, when you die in a revocable living trust, you now have it, your heirs have it at $100. That's great. You don't have to pay capital gains tax on that when you sell it. However, it's includable in your estate for tax purposes. So now your stocks are worth $100 and your heirs may pay tax on that if they're above any estate income tax threshold. For an irrevocable living trust, you are giving up the asset during your lifetime. So what that means is that your irrevocable trust is a transfer basis. So that Apple stock that you bought for $1 now is transferred to the irrevocable trust, and their basis in the stock is $1 because you gifted it during your lifetime and they pick up your basis. So when that irrevocable trust sells it after you pass away, they're paying capital gains tax on that Apple stock of $1 of $99, if that makes sense to everyone. So irrevocable trust picks up your basis when you originally bought it, while a revocable living trust picks up the basis when you pass away. So that's really the main difference between the two, is the difference in cost basis. But again, the reason why you're potentially moving things into an irrevocable trust is that you're trying to get money out of your estate for either tax purposes or Medicaid purposes. So unfortunately, with the irrevocable trust, you can't always balance estate tax with income tax.
If you, Blake Len Baskin, if you do not have a trust and you pass away, and your stock that you bought for Apple stock for $1 and it's now 100, you still have to pay a gift tax or just an estate tax. Do you have a capital gains tax on that?
So if you own it when you die, or you have any ability or string that you can make changes, sell it during your lifetime, etc., the answer would be you get a step up in basis. So if you die, no trust, you die owning, an Apple stock that was worth $1 and you die it's worth 100, your heirs get it at $100. So when they go and sell it for $100, they pay $0 capital gains tax. And as long as your estate's under $11.7 million, they pay $0 federal estate tax. There is no state estate tax today. And if the money goes to children or grandchildren, there's no inheritance tax. Because New Jersey is one of those funky states where they have multiple taxes, no surprise there, where New Jersey has inheritance tax, which means depending on what class of heirs you leave the money to, they may owe inheritance tax. So there's like 5 different classes for inheritance tax. Class A would be, your spouse or any of your blood relatives, which mean children, grandchildren, direct lineal descendants. They pay $0 inheritance tax. There is no Class B. They got rid of Class B, I think, back in the 70s and never replaced it. Class C is if you leave any money to your siblings, which means brothers or sisters. They get the first $25,000 tax-free, and then they pay 11% inheritance tax on anything they receive, other than like life insurance. So life insurance is one of those quirks that is not subject to inheritance tax if they have a beneficiary designated. So if you left your brother or sister life insurance and they were the beneficiary on it, they don't pay any inheritance tax on that life insurance. For whatever reason, a little nuance within the inheritance tax, code. Class D is pretty much anybody else. That's nieces, nephews, cousins, friends, the guy on the street. You leave anything to them, it's 15% inheritance tax on $1. And then Class E is charities. Class E for charities, they don't pay any inheritance tax. but you do have to do it's a filing requirement for anything that you leave to charity. Don't ask me why. It's another weird nuance that charities don't pay tax, but you got to file an inheritance tax return if you leave anything to charity. And that's, a quick overview of inheritance tax. And then estate tax, right now, with when former Governor Christie enacted that gas tax, as part of the rider is they got rid of the New Jersey estate tax. So that's why currently there is no New Jersey estate tax. So if you die with, let's say you die with $10 million and you left everything to your children, they pay nothing in federal estate tax and nothing in inheritance tax and nothing in New Jersey estate tax. So that's, for right now, New Jersey is actually a great state to die in. So it's a very, good thing to be when it comes to, passing away in New Jersey. It used to be one of the worst. Now it's actually, surprisingly one of the best ones for estate tax purposes.
If you leave money to somebody, let's say a friend who lives outside of New Jersey, does the state that they live in determine whether they pay an inheritance tax?
No, it's going to be based on New Jersey law. So it doesn't matter where the individual beneficiary resides, whether they're in, whether they're in New Jersey, California, North Dakota, or internationally. It doesn't matter. New Jersey will tax it under their borders and under their laws. So it's not under the beneficiary's home state. So if they were in a state like, let's take, Delaware, they doesn't have any inheritance tax. Doesn't matter. New Jersey's still going to tax them if they're subject to inheritance tax here in New Jersey. So that's why it makes it easier for New Jersey to monitor it, makes it easier for the attorneys to administer it too. They know if you're, a friend, a cousin, etc., you're paying 15% inheritance tax. So that's the beauty of it. And again, living trusts, like we said earlier, don't avoid taxes. So if you left everything in a living trust, you think, all right, I got around the inheritance tax. You didn't. So if you left everything in your living trust to a niece, a nephew, a friend, you still are required to pay a New Jersey inheritance tax. Because again, living trust doesn't avoid taxes, it just avoids probate.
Okay. Question on gift tax. People assume that if they give a gift, something greater than $15,000, that they have to pay a tax, but that's not true, is it?
No, that's not true. So what that is so anybody can give $15,000 per person per year. It's unlimited, meaning if I want to give everybody here, there are 13 people in total, not counting myself. There's 12. I can gift each one of you $15,000 today, and on January 1st, I can gift you another $15,000, and you pay there's no gift tax that I pay, and for you, it's like a big birthday gift, so you never pay the tax. So that's the beauty of it. And you and your spouse together can gift $30,000 a person. So my wife and I can gift everybody in this room $30,000 today, and another $30,000 January 1st. So that's what's called the annual exclusion. There's no reporting requirement required. You don't report it as income, and I don't report it to the the IRS. However, if I go over and above that $15,000, let's say I want to give Morley $100,000. Morley is been great. He's hard up for money. He could use it. I give Morley $100,000. Okay, no problem. I have a lifetime gift exemption of $11.7 million. So that $11.7 million came back again, right? We heard it earlier. That's the federal estate tax exclusion. So what happens is the gift tax exclusion and the federal estate tax exclusion run together. So if I want to give Morley, let's say $115,000, just because it'll be easier for my math. So I can do that. I have to file a gift tax return, which is a form 709, and I'm going to report the gift of $115,000. $15,000 is already excluded. So I'm using, out of my $11.7 million, I'm using $100,000 of my lifetime exemption. I don't know tax on it. It's just part of my lifetime exemption. It's a reporting requirement. So now when I pass away, anything over and above $11.6 million, I'm going to pay federal estate tax. So you kind of see how it, they kind of work together, where if, federal estate tax and the state gift tax are the same, but if one goes down, the other goes down. So they go down together. So it's not until I get over and above $11.7 million or $11.6 million. And that example is that I would have to then pay gift tax, gift tax. But again, I, as the giver, would pay it. The recipient would never pay it. And again, unless you go over and above it, it's just a reporting requirement only. Okay. Any other questions on the trust end or?
Richard, do you have any questions?
No, I was going to ask about the inheritance tax, but Blake covered that. So that's a little different than what I'm used to. I'm used to dealing with estate taxes.
Mm-hmm. But yeah, what area, what state were you from originally?
From New York.
Okay, yep. New York's one of those states where, they don't have inheritance tax. There's like a handful of states that have an inheritance tax. Pennsylvania is one of them as well. New Jersey is one of them, and there's a few others. But New Jersey always finds a way to get their money somehow, and that's why I think the easiest way to get more money into the state, and with Murphy winning the election, will be to bring the estate tax back to New Jersey, because it's easy to tax dead people. They don't vote to a degree, and most people aren't going to be impacted by it, so they're not going to say, oh, that's a tax for the rich. But really, in New Jersey, the estate tax, which used to be $675,000, was nothing. You owned a house and you were already above it. So, that's why I think at some point, I believe that Murphy, potentially will bring it back. At what number, nobody really knows. My guess is maybe $2 million, but it's just a thought. So that's, it's a very interesting nuance within the New Jersey, tax laws, always trying to find somewhere that they can, drum up money from people. Did anybody have anything on, any other types of trusts that they wanted to discuss? And I can move on to some more general things as well, if you like.
A quick question, Blake. And I know you may not know the answer. New York State, they have a state tax that starts if you make used to be over $5 million. Is that still the situation?
Yeah, it's actually now it's like $5.9 million.
Okay.
So it went up, and Richard probably knows it, better than I do. It's about 5.9, but it's like there's a cliff, and I'm not 100% familiar. But if you went over the cliff by I want to say 5%, but don't quote me on that, then I think you're taxed on like $1. Richard may be able to opine on that one.
What was that, Richard?
No, there's a cliff. So once you go over a certain dollar amount, then it's the exemption disappears and you're taxed on $1.
Yep. And I want to say it's 5%, but I could be wrong, Richard.
Okay.
So, but yeah, so that's why with New York, it's literally is a cliff, because if you fall off, you're like, oh, shouldn't I get the first 5.9 million free, and then after that I pay tax? Not in New York, for whatever reason, they put it so that if you go over it by X percentage, you're taxed on $1. So it's almost like you got to make sure you give away enough assets or do some tax planning so you don't get hit with that tax on $1. And then, Pennsylvania does have, if you have family, or people that that are residents of Pennsylvania, Pennsylvania does have inheritance tax on children. So children pay inheritance tax in Pennsylvania, while New Jersey, you do not have inheritance tax on children. So again, like I said, one of the benefits of being in New Jersey, if you're leaving everything to your kids right now, is there really won't be any estate tax issues. Okay. Does anybody have anything in particular on trusts, or we'll move on to some things about the will? Because again, with the will, we're gonna there's trust within the will too. I mean, that's called a testamentary trust. So a lot of people will talk about what do I want to do something for my kids, but I don't want to lose control of my money right now. Okay, you don't have to. So the beauty is that you can create trust within your will. And that's called a testamentary trust, which means it's a trust that occurs when you pass away. So with that trust is, a lot of people will say, all right, my kids they're young, or I don't like their spouses, or I'm concerned about the, creditors. They got, they're young and stupid. I don't want them to blow, my money that, we worked so hard for. So in that case, what we did was we set up a testamentary trust, and you can control at what age or ages you would want the kids to get the money. So for example, you might say, all right, my kids are, 30 years old, but I don't want them to have it. They're still too young, too mature, too risky. You can set up the trust so they get it, at 40. They could get it at, 45, 50. You can spread it out over numerous years. You can give them X% a year. You can give them, based on age, and you can also put it into trust for a lifetime. So a lifetime trust is just that. The trust is, they have money set aside for them, but they don't have unfettered access to it. So if you're concerned about, your child's spending habits, they're a spendthrift, or you're concerned about their marriage, they may have a shaky marriage, or you just, or they have a history of addiction issues, and you're just not comfortable with giving, money outright to your, child or children, then you may want to think about a lifetime trust, which can be good, for you, that you think you're doing, protecting your kids. They may not like it because they don't have access to the money. They have to ask permission from the trustee to access money. So that's kind of the good part of it, is that you have somebody else that kind of is that mediator that says, do you need the money? What do you need the money for? Because the trustee's goal is to protect the trust and to make sure that the trust is not being spent frivolously. So if somebody has a trust, and let's say it's a trust till they're 45 years old, and the person's like, I want money. Okay. The trustee's like, all right, I can understand that. Times are tough. What do you need money for? I want to buy a car. Okay, that's fine. What type of car are you looking for? Well, I want a Lamborghini. I need $100,000. And the trustee's gonna be like, that's great, but I'm not paying for you to have a Lamborghini, right? Because that's not a good use of the trust money. And I'm the trustee, and I'm here to protect the money and to make sure it grows and it lasts, till you're 45 years old. But I do agree you need a car. I'm going to go, can we agree that if you want to get a Toyota or whatever car they're accustomed to, to having. So if they've always had, a Toyota or a Honda or, an Acura, a Lexus, you want to try to keep that at the same level. So, all right, I want a Toyota, okay. No problem. The trustee is going to say, all right, I'll buy it, but I'm not going to give you the money directly. I'm going to pay the dealership directly. So that's one of the ways to ensure that the person is using the money for what it's intended to, by paying it directly. Or somebody might say, I need money for my rent. I don't have money for rent this month, and they may be lying to the trustee, or they may really be in need of the money for their rent. But the trustee is not going to take their word for it and say, here, Blake, here's, $2,000 for your rent this month. He's going to say, all right, Blake, give me the name of your, let me see your lease, and let me, I'm going to make out that payment to your landlord. And that's what the trustee is going to do. So again, the trustee's in there to protect you from yourself, whether you like it or not. And the trustee has a fiduciary duty. So the trustee is also going to want to make sure that they're investing the money properly. So a lot of times I tell my clients is that, don't take the responsibility to be the investment person as well. You're the trustee. You're responsible for protecting the money, making sure it's invested wisely. It's not your money, right? You wouldn't invest in how you would do it. You got to do it conservatively. So you reach out to your financial advisor. You reach out to somebody like Morley, who specializes in this area. And you would basically say, all right, I'm the trustee for, the Len Baskin Trust. I got to make sure that this, stays the same or grows until the beneficiary is 45 years old. What should I invest in? So, that professional will tell you, okay, you're the trustee. You have to make sure that you are investing it wisely, conservatively. This is what I would suggest. You might say, okay, that's a good plan. That is, seems wise. And what you're doing as trustee is you're trying to move the liability from yourself to somebody else, to another professional. So that way, if, for example, if, Morley invests it and he puts it all in, I don't know, an international stock in Greece, and it falls out, the recourse would be against Morley because he was the advisor on that versus you doing it yourself, where Blake invests it into, into Greece thing. And this is going to be a hot, let's go ahead and do it. And you lose everything. Then Blake gets sued, by the beneficiary. So the benefit of, having a professional advise you is you also, as trustee, moving that liability from yourself to somebody else. And that's kind of the name of the game, right? You're taking on this responsibility to ensure that, a family member or whomever, his money is protected, but you don't want to at the same time do a good deed and then you get, sued. You want to have some plausible deniability and at least another pocket to dip into should that happen. And that's why I tell all my trustees to make sure, don't do your own investing. Whether you think you know the market, you think you know what you're doing, it's not worth a potential liability. You want to put that onto somebody else. Because the kids that are now, of age or are now 45 say, hey, Blake, all right, I'm 45. I want all my money. And Blake's got to say, I hate to tell this to you, but I lost it all. You know what's going to happen? They're going to talk to an attorney and they're going to sue, they're going to sue Blake if Blake invested it, or they're going to sue, whoever the professional was that invested it poorly. So that's why you want to always be cognizant of your fiduciary duty to act on behalf of the beneficiary and not yourself. And even if you say, well, the beneficiary told me to invest in this, it's not going to matter. When you lose the money, if the money is ever lost, they're going to say, well, what did I know? You're the one that's supposed to be protecting me. You invested it, I'm going after you. So that's why you always want to, protect yourself in whatever role you're in, when you're a trustee, of a irrevocable trust, a trustee on a testamentary trust, et cetera, to make sure that there's always somebody else that's advising you that's, smarter than you are, that you can potentially shift liability over. Because that's always a big thing, is that you're trying to do a good by, the person that passed away, by looking after the money, making sure that the money, the assets are protected. You don't want to, in the same time, get yourself sued, for that. So that's probably the most common that you'll see in most wills, where there's going to be a testamentary trust set up for, kids, grandkids. We'll put, sometimes we'll put special needs trusts, within the will as well. But, ideally you want to have a special needs trust outside the will, because when you have the special needs trust outside the will, not only can you contribute to it, but other people can. So if you have, parents, grandparents, aunts, uncles that want to leave money to this person, instead of leaving it to them directly, you already have this special needs trust set up. So you can say, all right, I'm going to, here's the name of the trust. It's the Blake Laurence Special Needs Trust. If you're going to leave any money to Blake, make sure you leave it to him in the special needs trust, because we need to preserve his, government benefits and, what he's getting. Don't leave it to him directly, because that will, mess up his benefits. And I work really hard to get him on. So that's why, it's important to, to make sure that whatever trust you set up is serving a purpose, what that purpose is. And a testamentary trust, for, kids, grandkids, et cetera, is going to probably be your most popular. And the beauty of it is you still have the money. It's whatever is left over, depending on how you earmark it, that's what goes in that trust. So you still have control, you still have access to that money. But again, and you still, to Len's question, you still get to step up in basis on that stock. Because if you die owning it, and owning it means you can sell it, you can buy, you can sell it, you can do whatever you want with it. That means you owned it on your death. It's includable in your state for tax purposes if there's anything owed, but you get to step up in basis. So a very important piece of it, because again, everybody's trying to avoid capital gains tax, as well. And if you're not worried about, long-term, Medicaid or anything else like that, or, federal estate tax, it's a great way to take your low basis assets, own it until you pass. And the same thing goes for real estate too. If you own a piece of property that's, that you've had since, 1950s, and, you own it when you pass, well, guess what? You may have paid $10,000 for it. But when you pass away, it goes up to fair market value. Because again, you owned it when you passed away, you get a step up in basis. So therefore, if you then sell it, your heirs sell it for, whatever it may be, there's no capital gains tax, or the capital gains tax is the difference between fair market value when you died compared to when you sell it. So there's there's benefits to everything you do, and there's also cons to everything you do.
One thing, Blake, just to keep in mind when you're dealing with trusts, the trusts are taxed on their income or it's passed through to the beneficiaries.
Mhm.
So that's something else that needs to be considered in all of this.
Yep.
You know, who's going to be paying the tax? And the way the trust tax rates are set up, you get to the highest tax bracket at about 12, 13,000 of taxable income.
Mhm.
So there's, in addition to looking at capital gains, you also need to think about the income and who's going to be paying tax on the income. Because the trust income is not going to avoid taxes for the most part.
No, 100% accurate. So on a living trust, you know, there is no trust income typically that'll be going on to your personal income tax return. But when you have certain trusts like irrevocable trust or the testamentary trust that you had when you passed away, you're going to be doing, and Richard's 100% accurate, a 1041. And if you don't pass out the income to the beneficiaries, the trust will pick up the taxes on it. And, you know, with $12,000, $13,000 of tax, you're at the highest tax bracket, which, you know, is basically 40% to round up. So income tax doesn't go anywhere. If you're making money, the government's going to want a piece of it. And estates and trusts are taxed at the highest, you know, rate. If you can pass it out on a K1, you know, most accountants will recommend that. But again, you got to pass out the income too. You can't be like, I'm giving you, you know, at least I've seen, and Richard, you can correct me if, you know, you see it differently. If you don't pass out the income, you can't pass it out on a K1. I mean, sometimes maybe, you know, people have done that, but technically you're not supposed to.
Right.
So, yeah, so, you know, capital gains tax, you're right. You can sometimes avoid some capital gains tax with a step up, but, you know, long-term trust with the income, the dividend income could be dividend income, right? It doesn't have to be from a sale. Like capital gains, it could be the dividend income that comes in. The trust is going to end up paying for it. So, you know, that's why the investment vehicles, maybe you want to, you know, change up how you invest the assets, or it could be one of those things where it's just part of doing business. If you're doing it for Medicaid purposes, there's a reason why you're getting it out of your, you know, your estate. You know, paying the income tax on it is probably better than losing the asset, you know, spending it down for Medicaid purposes. So definitely, you know, a good thing to consider. You know, you got to look at estate tax. You're going to look at, you know, inheritance tax. You're going to look at capital gains tax. You're going to look at income tax. You know, when you look at every tax that there is, and then you have to make an informed decision on where your risk tolerance, you know, is. If you're, you know, very adverse to one, that may change on what you decide to do. So definitely, you know, everything that we do has a tax consideration, and you should be talking to your, you know, your attorney, your accountant, and your financial advisor before you make any, you know, drastic moves when it comes to the taxes. You know, you have those professionals there, you trust them for a reason. You know, make sure that you are using them because they're there to guide you and help you and to understand your concerns. And, you know, ideally they're there to, if they can, minimize your taxes. They can't, you know, maybe not avoid it altogether, but if we can minimize it, that might help you in whatever, you know, route you decide to go, or, you know, when it comes to doing the trusts.
Like
Like,
in a
would
special-
you, like Alan Lieberman, would you talk about IRAs going through a trust?
Sure. So a lot of times now, like with the IRAs, you know, they have the Secure Act now. So with the Secure Act, it is, you know, you got to take all the assets out within 10 years. So a lot of times you're trying to find a way that you can stretch it with the RMD. I don't know the answer with the trust with this and how it plays in with the Secure Act. It used to be you'd be able to take the RMD through the trust to stretch it out. But I'm not sure. I got to take another look at it because it's been a while since I looked at it, how it would play out with the Secure Act. Because the Secure Act says that you're supposed to take out when somebody passes away, you are whatever the money is within 10 years. It doesn't have to be all in year one. It's not 10% a year, but within 10 years, everything within that IRA has to be taken out. I'm actually looking at that for a client of mine that had that exact question. So I can certainly get back to you guys on that one of how a trust and the Secure Act, you know, plays together with regard, can we stretch out the IRA longer than the Secure Act allows, you know, through the trust and using those RMDs.
Blake, and the special needs trust, is that tax free? Is the income tax free or it's all taxable?
It's still the same rules. morally. So just because it's in a special needs trust, depending on what the asset is, there's still going to be, income tax for any gains, dividends, income that comes into it. They're taxed the same way, on a 1041. I mean, it's
Okay.
different. The setup is different because you have to have certain language within that special needs trust in order to make sure that the government can't come in and, invade the trust or say, you don't qualify because you forgot to add X, Y, Z. And therefore that's an accountable asset for the person that has special needs. But the tax consequence would be, the same, whether it's a special needs trust or an irrevocable trust.
And what happens if the person dies before the money's used up? Do you specify where that money goes in the trust?
Yep, and a third-party special needs trust. So a third-party special needs trust is where somebody else sets up the trust on your behalf. So let's say I have special needs, Morley sets up a trust for me. Morley can dictate when Blake passes away that has special needs where that money goes. Typically, you would then have it go to, your other, if you had other kids or somebody else, you'd have that money go there. But if it's a first party special needs trust, where it means, let's say that, I had special needs as a result of a medical malpractice. So I set up, Blake sets up a first party special needs trust. So what that means is that it's Blake's money that's used to set up that trust. And therefore, when I pass away, it has to go to pay back Medicaid first, and then everything else, it's got to go by intestacy. So the Medicaid rules don't allow on a first party special needs trust, which means the individual that special needs own money, they dictate how it's supposed to go, and it's always to go to pay the Medicaid back first for any money they laid out, and then it would go by intestacy under for Blake's heirs.
Okay, maybe I think one thing that a lot of people don't understand is what happens if you don't have a successor trustee or a successor executor. What happens? How difficult is it to get the estate settled?
It's not that it's overly difficult, but it's time consuming and expensive because you have to go into court and either petition the court of why somebody else should be it, or potentially you have to get renunciations from other people in the same line. So for example, if your executor is your spouse and you have 3 kids, but your spouse passes away and the estate's not finished, 2 ways, you can go about it is you can go into court, petition the court to have a certain, one of your kids to be the trustee, or you can attempt to, have them renounce and have, one person do it or all 3 of them do it. But potentially, you're going to end up on what's called an order to show cause and verified complaint to have the court appoint a successor trustee. So a successor executor in that example. So you always want to make sure that no matter what you do, you have, I always like to have a primary and at least 1 backup. And depending on what their ages are, I may say you want a 3rd backup. So for example, if you have somebody that's, that's your spouse, that's fine as the executor, and the next person is the same age as you are, I might say that's fine, but let's get somebody like a generation or 2 younger than you, just in case. It's easy to, you're not going to name 100 people, but you want to make sure that should something happen to you, or even that person you picked, you have at least 1 generation lower that can hopefully hedge that bet without having to go into court with court intervention to try to name a new trustee or a new executor. So there's lots of different ways. I mean, the court's there to help you, but unfortunately, you're looking at additional costs and time in order to get into court. And with COVID, things have gotten a little slower. The beauty of COVID, to a degree, not that it's beautiful, but it's gotten courts to modernize a little bit more. So it used to be that you had to physically go into court. But now with COVID, the courts have spent a lot of money to upgrade their capabilities. So a lot of their situations, their meetings, their conferences, some of their even motions are all done via Zoom. So it, which makes it beneficial because it used to be somebody had to fly up from wherever they were. They had to spend half their day in court just to hear other cases before they heard their own. So now, with the modern technology, the courts are, embracing it. They're kind of forced to. They're able to do a lot of things via, Zoom and other types of devices where the court can see and hear you, but you don't have to be physically present in a courtroom. So that makes it, convenient in one respect, but during the holidays, the courts don't have a lot of capacity because they have during Thanksgiving to Christmas, there may be only a couple motion days. So if you get caught in that situation where somebody passes away, in October, you may not get in until, mid-December or not even January, because the court only has so many days to hear these cases, and they don't hear them every day. They pick, one motion day every 2 weeks. So figure 2 a month. With, Thanksgiving, November, it's, could be only once a month. And with Christmas, the holidays there, it may only be once a month. So everybody's trying to cram everything in. And if they don't hear you, they just put you to January because they can do that. They get to control their courtroom and what they hear. And unfortunately, you as the litigant or as the person or the lawyer has no say in their calendar unless it's a real emergency. Other than, major emergencies such as a medical issue whereby somebody has to have a life-saving procedure, different story. But for the run-of-the-mill things, they would just do it whenever it's convenient for for the court versus your client and the lawyer.
Okay.
So that's why make sure that again, and also you want to make sure that you have, no matter what you do, you want to I do a lot of work with people that don't have wills. It's always faster, cheaper, easier, no matter what it is to have a will, so, if anything is, do a will. It doesn't have to be complicated. Keep it simple because it's better than nothing. Because if you die without a will, it's thought you die intestacy, which means no will. That means you have to do an administration. So a lot of times on administration, the court will have to bond the person applying to be the administrator. If it's a spouse, probably not a big deal. But if it's the kids, all the kids have equal standing to be an administrator of an estate, and they have to be bonded, for the value of the estate. And you might have a house that's worth, let's say, $1 million, and you have a $500,000 mortgage. The court will bond you for the $1 million, even though you say, "Hey, I owe $500,000. I don't have value." They take the position, especially in Monmouth and Middlesex County, that we don't care. We're not getting involved in it. It's worth $1 million. We're bonding you for $1 million. You figure it out. And with that bond, with that cost, the higher the bond, the higher the value of the estate, the higher the bond costs. So again, it can take a lot more time and a lot more money to administer an estate through someone without a will versus just having a will, even if it's simple. Everything to my spouse, to my kids. Here's my executor. There you go. Doesn't have to be complicated, but something is better than nothing. So at the very least, have a will, and that will save your estate, a lot of money and a lot of time, to do that.
Morley, Michael, you have any questions?
I'm good, thank you.
Okay,
It's very interesting.
okay. Gary, you have any questions? I don't know whether Gary's still there, but okay. Steve? No, okay. Anyone else have questions? Is there, Mike Eisner? You have a question? No?
I'm covered.
Okay, well, this is recorded, and the MO is to get it edited by Steve Birnbaum, and then I post it up on the Stonebridge YouTube channel, which can be searched by Stonebridge Investment Discussion Club. There are several Stonebridges on YouTube, but if you do that complete name, you go to directly to our site, and you can see all of our recordings, including the one from last month and backward. Blake, I don't know whether you have any other remarks to make, but I appreciate your coming.
No, my pleasure. And like I said,
Maybe you could tell people how to get in touch with you if you'd like to.
Sure. So I'm a shareholder at the law firm of Davison, Eastman, Munoz, Paone. We have an office in Freehold, which is not too far from from Stonebridge. I also have an office in Toms River. You can call me, you can email me. My phone number is 732-462-7170. And my email address is blaurence@respondlaw.com. B as in Blake, LAURENCE @respondlaw.com. If you have questions, concerns, you want to bounce something off, of me, feel free to give me a call, shoot me an email, and we'll get back to you, with an answer.
Okay. All right. Well, everyone, I guess that this is conclusion. So everyone have a happy, fulfilling Thanksgiving, and we'll see you next month.
Yep, and thanks for having me as well. It was a pleasure to speak to you guys and see you virtually, kind of the new norm lately.
Yeah, right. Well, we could meet in the clubhouse, but I decided that this would be easier for you and for us.
No, it was perfect. It was great.
All right. Thank you very much.
All right. Thank you.
Okay.
Happy Thanksgiving, everybody.
Thank you
very
very
much.
much.
Bye-bye.